So we were
two.
talking a little bit about false allegations, I think, is what we're talking about. And just, in what way is that meaningful to us, and how do we, how would we approach that at Friends of the Family? For sure. Like, it's something that we make we don't send people away, right? Like, we don't decide. It can be really dangerous for us to decide whether or not someone's making a false allegation or not. There's typically more to it than, what that person might be alleging when they come to Friends of the Family. And often, victims are frequently very reluctant anyways to share information. So there's ways of identifying, whether or not, what someone is reporting is, is valid and real and, has that piece to it. So, yeah, I mean, I think that we try to just make sure that they're getting the services and help that they need, and there's a wide variety of services that make a difference in terms of a case that we take for legal representation, for sure.
So welcome to the Consultation, guys. My name is Josh Floyd. This is Christina Jimenez. We're both attorneys at Jimenez Law Firm here in the state of Texas, and we have with us Donna Bloom. She blessed us with her presence today during Domestic Violence Awareness Month.
Yeah.
And so, as you can tell, we're going to talk about some domestic violence, and we may go down 100 different rabbit trails.
Likely so.
Yeah, for sure.
And
Yeah.
so, Donna, you want to tell them about yourself, what
Sure,
you do?
you bet. So my name is Donna Bloom. I'm the Director of Legal Services at an organization in Denton County, Texas called Denton County Friends of the Family. That is Denton County's sole provider of domestic violence and sexual assault services here. And I am an attorney that represents victims in various forms of civil litigation. But I'm a part of a greater organization where we provide a lot of services that we can talk about in a moment. In terms of my background, I've been an attorney since 2006. I've been at Friends of the Family since 2007. So I'm entering my 17th year practicing here in Denton County and representing survivors. Prior to that, I worked briefly with a statewide organization called the Texas Advocacy Project that is a wonderful resource for victims across the state of Texas, and they have a family law legal hotline, and they do various forms of direct representation, some impact litigation. So I was there for a bit. And prior to going to law school, so I'm a sort of late into law school person. I started law school when I was 33. So
I wouldn't have put you over 33 right
yeah,
now.
right, exactly. Thank you. For those of you doing the math, yes, that's 53, almost 54. Before that, though, I worked in the domestic violence movement in Texas in various roles, the last of which was running a shelter and rape crisis center in Longview, Texas. So, yeah.
And I will tell you that we have had several cases against you.
Yes.
We hate
yeah.
And she's hell on freaking wheels. It's like, Donna,
Donna got hurt.
what are we going to do?
Well, that's so funny. I think people that aren't lawyers probably don't know, as attorneys, when we are taking a case where the case has already been filed and there's an attorney attached on the other side, how that does go into sort of decision making about, whether or not, whether we can take a case or whether we want to take a case. And so, yeah, that does happen. And I will say in my office, when I see that the Jimenez Law Group is on the other side, I always see that as a good thing, because I know that, again, as attorneys, like, it's good to have like good relationships, to be able to talk to one one another. I think when folks, especially survivors, when they retain an attorney, they're very anxious. They're really scared about the threats that have been made against them, especially legal threats, and they want like a certain kind of representation. And I'm sure you guys have experienced this too. That people talk about like wanting a bulldog or something like that, and in my experience, you want to be zealous, but you also really want to be able to work well with the attorneys in your community because, again, survivors very typically don't want to go to court, right? Like they're very frightened, and that factors in to my representation. And so it's really important that I have good working relationships and have some level of respect from colleagues in the community, that I'm going to be reasonable. It doesn't mean I'm laying down, but, reasonable in terms of practical and having good client management and managing client expectations. So, we have had some cases together. I think that they've resolved well.
Right.
I'm hopeful your clients were happy with the result, and my clients were happy. And ultimately, what I think we all want is for folks to have court orders that are safe and workable for their clients.
So I know a lot of times when we're talking and we're negotiating, we're always looking at, well, what do we think judge is going to take?
Yes.
So here's this fact and here's that fact.
Yes.
And kind of combine them. And that's the great thing about having experienced lawyers on each side is because we can all kind of say, this is what judge is going to do, so let's bypass the BS.
Yes.
Let's just get to this order and let's find the happy compromise.
Totally. What's so funny is when I early in my career, a very common refrain for opposing counsels on cases with me is like, get me on the phone to convince me, what a liar my client is, that she's making this stuff up, that she's actually the person that's abusive, or mentally ill, or a substance user, or all the things that, might be coming up. And, I would, be a little bit more aggressive with those conversations. And over time, I've gotten to a place where I just really easily say, I'm like, hey, listen, let's skip the part where you try to convince me not to do my job and I try to convince you not to do your job, right? Because the truth is we're both going to do our jobs, right? And so I have really good, I feel like, client assessment when I'm taking cases. There are way more people coming through Friends of the Family that need representation, that can't afford to hire y'all. I've made, a good number of calls to you guys to, hey, what do you think about taking this at low bono? This person can't come up with a lot of money, but they can come up with some. I spend a lot of my time doing that with attorneys in the community. But when I take a case, I generally feel very good about my facts. And I often will take cases that there is more nuance in it, where it's not an obvious slam dunk, if that makes sense, right? Like those I can place out, those I can convince other attorneys in the community to take. If I've got a victim that has, their perpetrator has multiple criminal cases pending against him, I've got really good evidence of the violence. It's very clear. Those cases are a little bit easier to place, right? Because they're going to be less litigious. They're going to be more easily resolved. We know what judges are typically going to do. If you've got, good physical evidence, it's pretty obvious what's happening. I usually will take cases where maybe there isn't as much physical evidence. Maybe we have to dig a little deeper into the context of the violence that's occurring. And, that
takes so much time and money.
It does.
Whenever you're working cases like that as a private attorney.
It really does. And it's so hard to, we, over the last year and a half, had a grant from the Texas Bar Foundation to build out a network of attorneys that would agree to take what we call low bono, not necessarily. I have a really hard time, so let me pitch it right here. If there's any attorney watching this that wants to take a pro bono case, I have a really hard time placing pro bono cases, especially domestic violence pro bono cases, because y'all know, domestic violence is not about physical violence. It's about power and control and domination. And so litigation abuse becomes is the way in which someone will continue to attempt to control their partner when they've left, which makes it really expensive.
I've said that so many times, like over the course of my career, of like, listen, get ready because now that he can't physically abuse,
Right.
this is going to be the new process.
That's right. You shift. So people that use abuse and violence in relationships, it is typically about wanting to be in a position of dominance and control. And when that person that's being victimized steps out and takes that really courageous step to challenge that person's dominance, to challenge that person's control, they're going to shift strategy, right? So they no longer have proximity access, right? So they can't sort of physically intimidate you, but there are a host of ways to harm somebody that don't include physically abusing them. The use of the child welfare system, the use of the criminal justice system, and then just the use of the civil legal system. Things that are, available to all litigants, right? So I have some cases where the respondent or abuser in that case is using an attorney to utilize the procedural tools that are reasonably available. But my clients don't understand that.
Right.
It feels like litigation abuse, right? They're having to go back to court a lot. They're having to tell their story a lot. They're getting results that they're not that are scary for them, and it's something that you have to. I guess that's one of the skill sets that I bring is being able to talk to a survivor about the reality of the civil legal system and what that's going to look like. Now, the good news for folks that I represent is it's free to them.
Right.
And I think a benefit to the respondent, especially if they're married, because I pitch to opposing counsel, like, I am saving the community money right now.
Right.
I'm not just saving my client money. I am saving your client money. And I will. That's one of the things I will typically negotiate on is attorney's fees. So, in protective orders, for instance, if I can prove up a protective order, I'm very likely to get my attorney's fees. And a lot of people don't know. A lot of attorneys don't know that legal aid providers or public interest attorneys can seek attorney's fees. Now we're seeking it on behalf of our organization, and that money goes to Friends of the Family. But you know what? I'm not free.
Right.
Someone's paying me, right? It is costing the organization money for me to represent this person. And so the benefit on some level for an opposing party is we can negotiate away those attorney's fees because it is something that the client's not experiencing. We can absorb that at the agency. And so it's a benefit to both parties because we can sort of move past, reach some agreements, and one of the things that the opposing party can walk away with is an order that doesn't include that they have to pay thousands of dollars in my attorney's fees.
Right.
So
kind of in that context, talking about like family law in the context of civil litigation, like what it is, how do we define it, when do we see it come up? I guess family violence defined.
Yeah, so this is such an interesting topic because, when I train lawyers or when I'm talking to victims, Texas in the family code has a very specific definition for family violence that's very linked to physical assaults or imminent threats of physical assaults or sexual assaults, which is not the definition that we use in our work because that's really just very often a small piece.
So just to clarify, when you say that we use, you're talking about
at Denton County Friends of the Family, but really in the domestic violence or what we call gender-based violence movement.
Okay.
We talk about domestic violence much more broadly. And so when you heard me talking a moment ago about violence being about power and control, that idea of power and control is really not encapsulated in the family violence definition in the family code. It's like really focusing on physical assaults and not so much the wide range of tactics and strategies that an abuser can use in a relationship to gain control. So, for instance, We talked a little bit about the use of financial control. That's obviously a really big piece. Spiritual violence, especially where we live, right? Like people's faith is very important to them. And there is really not a faith tradition that cannot be exploited to dominate and control. And so that can be a big piece of what's going on. Emotional abuse, verbal abuse, threats, and maybe not threats to physically harm someone, but what kind of threats have you guys seen? Deportation. So when you have immigrant, or undocumented folks that you're working with, that can be a really scary threat. The child welfare system is widely used by abusers, not just the threat of it, but utilizing that system, right? One of the big changes in the legislature this last session that I think is probably a positive change is you can no longer make an anonymous child welfare report.
Right.
Yes.
And so in my world, that's very important. That's a good thing because abusive people will use whatever systems are available to them to harass and threaten their victim. And if you have a system that is not well educated or super knowledgeable, or is really looking at surface type information, victims can be further victimized by those systems.
A lot of the times whenever we have those types of calls from the department, so typically what happens is there's an investigation, the CBS caseworker calls our client tells us, and then we call the caseworker. When I have that kind of history or pattern of that sort of abuse, I spend probably 30 minutes just explaining to the caseworker, here's all the backstory, everything that you need to understand, so that you have perspective going into this investigation so that it doesn't become another form of abuse.
That's right. And also, often our clients are fearful of the child welfare system. They, either have had experience in the past, or they have extended family or friends that have been involved in the child welfare system, or they just read the paper, right? Or read news sources or on social media, and they hear about kids getting removed and placed into foster care. And so, if a person that uses violence in their relationship is willing to weaponize the child welfare system, it can be a very effective tool.
So one of the things, and I don't know if y'all have similar experiences with this, but oftentimes when I'm presenting these other forms of abuse in court, the emotional abuse and the deportation threats and things like that, sometimes I feel like it falls on deaf ears with some of the judges.
It's difficult.
Yeah, I think it's really hard. And again, like in my context, when you're talking about domestic violence, it can sometimes be difficult with judges because if they're relying upon that very narrowed definition, right? And that definition isn't just used for protective orders, for instance. In Texas, that definition is used for conservatorship. So, rights and duties. Can my client be a sole managing conservator? And in our system in Texas, if you can establish a pattern of child abuse and neglect or of family violence, then the court should consider naming one of the parties sole managing. And the reason for that is it's very difficult to co-parent or be a joint managing conservator with someone who's willing to use tactics of power and control, right, to harm their partner. So I think part of that's just the limitation that judges have in terms of definitions and really being able to contextualize the information, right? So being able to say, Judge, threats to deport someone. I mean, I have text messages here, Judge, that are very clear that this person is using really a form of, terrorism with this person, right? To, threaten the police, threaten to take the kids away, threaten to call, the authorities about their undocumented status, right? And, it is, I think, an art form to tell that story in a way that a judge can understand goals of those behaviors. That's the point, is why is this person doing this? And they're doing it to gain and maintain control, and it should further support the violence that we are alleging is occurring, right? So if we're saying there's been physical violence, and maybe we don't have a lot of like evidence, right? Maybe she is undocumented and she's not going to call the police. She's fearful of calling the criminal justice system. Or maybe when child welfare showed up, she didn't tell them everything about what was happening because she was fearful of that system. And so we don't have a lot of evidence. What I try to do is establish for the judge sort of red flags that would help support the client's allegation that she's being physically assaulted. And I think that our judges are becoming more and more nuanced in their understanding of what domestic violence really is. I just think that sometimes the definitions in the family code really limit the court's ability to acknowledge what we call coercive control, to acknowledge that coercive control in a way that would get our clients the remedies that they're seeking.
Right.
Right. So, yeah, I mean, and that's, I think what we were talking about at the beginning is like, or maybe before we've been chatting for a while. So, I think our jobs as attorneys, and my job in this very specific intersection, is to manage a client's expectation about what a judge is going to do, what our experiences are with that court, and whether or not we really want to roll the dice, or whether or not we want to try to reach some kind of reasonable agreement that my client can live with.
Right. So we kind of talked about it, the definition, then we talked about, sole managing conservatorship. The other way that we see family violence defined is through protective order.
Yes.
And so let's talk a little bit about that.
Yeah. So in Texas, we have a pretty unique setup in Texas. Every state's a little different. And also the terminology that's used in every state's a little different. So you might, people get confused about using the term restraining order versus protective order. And that's because in some states, what we call a protective order is called a restraining order. So first we start with just education for folks about understanding in Texas what the difference between a protective order and a restraining order is. And and I'm not telling you guys anything but for your, watching and listening audience, restraining orders in my work they can look very similar to protective orders. They can prohibit very similar behaviors, but the police are not going to be able to respond and react to those. You're going to have to go seek remedy in a court from a judge if the person is violating those prohibitions.
Before you get off the restraining orders, there was a change September regarding restraining orders. How do you feel about that? The no GPS tracking, all that stuff.
Yeah, I personally, I'm very happy to be, that the legislature is kind of catching up with technology. Obviously tracking a survivor is very common in my cases, right? And so many different ways that you can track somebody, right? So it's criminal, right, to attach a GPS tracking device. I have a few cases right now that are criminally charged with that, but it makes it much more complicated when the folks are married, when the vehicles are community property, right? And so there's so much nuance there that I am absolutely think it's imperative that we have restraining order provisions when we're going through litigation, like a divorce or custody suit, that one party cannot track the other party.
And I think that one may even extend. I think it was put in for survivors.
Yeah.
People that have been abused. But I think it'll extend to, sharing Live 360.
Yes.
Right? I don't think that they could track them that way.
Right.
It's something that's so common you don't think about. Oh, I need to turn off my Live 360 when it's separated. But if you don't, they can still follow you. So now I think that prohibition would...
I think
help that.
I think it does help, and I also think it's an indication that, Christina, you were talking about a minute ago, like judges maybe not taking seriously some of these other things that are happening that can establish that there's abuse or violence.
And Christina doesn't really like judges.
Well, listen,
Judges.
not true judges. We love you. But I think the fact that they're, including those provisions that we can include in restraining orders, it does convey to a court some measure of education about the various strategies that are used, and it raises the level of concern. And so that I think is really good, because the tracking issue has been going on for years. And, when people come into shelter, we have to teach them. We have a whole technology thing about how to turn your location portion off on your phone, right? So that you can feel safe.
Can you teach me that? So
exactly. Yeah, exactly. Or going into airplane mode, right? When you're at the shelter, if that's possible. We've had clients, in our building, meeting with me that are, concerned about being tracked, but also not wanting to turn those things off, because by turning them off,
notifies them.
They're absolutely putting themselves at risk.
Right.
At least they can come up with a reason why they were at Friends of the Family, right? Like, I need counseling, right? And we can help them with that from a safety planning perspective. Does the person that's hurting you know that you're here, or can they know that you're here somehow? And equipping them with, how to address that with the person that could be tracking them. So yeah, I think that's helpful. I mean, restraining orders are useful. Injunctions are useful in terms of creating lines to color inside of. And so when you have parties, or in my case, a respondent or an abusive person that wants to be perceived as someone that colors inside the lines, injunctions or restraining orders can be useful, because they will follow them generally, especially during the pendency of a case. But protective orders are obviously the much more valuable resource for someone that's being victimized, because, as you guys know, once you get a protective order, there are certain provisions in that order that are criminally enforceable. So for us, what happens is, once that person gets a protective order, it goes into what we call, it's a TCIC, which is the Texas database for law enforcement. So they're able to pull up whether or not there's a protective order. And what that does is, for a victim that has reported to police over and over again and maybe not been taken seriously, or what they're alleging is being minimized in some way, the protective order immediately raises the level of concern for law enforcement. So it can transform the law enforcement response to that victim, and therefore create a safer community for everybody.
Right.
It also, can prohibit, the possession and ownership of firearms, which is in limbo right now. As you guys know, there was a Fifth Circuit decision that is applicable to Texas, because we're in that circuit that has said that the prohibition of firearms in a protective order is unconstitutional. It's on cert to the Supreme Court, so I suspect that they'll be taking up that issue this go round. We'll see what happens with it. I'm sure this comes as no surprise to you guys, but I think it's absolutely absurd. The idea that if you can establish violence, that there can't be a prohibition on firearms included. The single leading cause of death of women in intimate partner violence relationships is with the use of a firearm. So in Texas, in 2022, I think we had, I think it's 212 homicides in intimate partner violence relationships, and well over 50%, maybe 60% of those were with firearms. So there's a direct connection between access to a firearm and and homicide and suicide, frankly. That's the other thing with domestic violence is threats of suicide are real red flags for us in our work. Sometimes people who use violence make threats of suicide as maybe they're empty threats, right? Maybe it's a way to make my victim emotionally responsible for me. Right? Which is normal, right? If we have someone in our life that we really love and care about, even if they're hurting us, right. If they tell us that they want to end their life, we respond to that. We want to make sure that they don't do that. We feel responsible for that person. So it's very effective. But there is a massive connection between suicide and homicide. So if someone is suicidal or they say they're suicidal, in my work, that means they're homicidal across the board. If someone is making allegations, if my client shows me text messages or communications about the person that's using violence in their relationship saying they want to die or they want to end their life, I treat that as a homicidal threat. Now, maybe that's personal background. I don't know that I've ever talked to either one of you guys about my personal background, but my mother was 10 years old when her father murdered her mother and shot himself. And so my mother and her siblings all went to a children's home, and my mom actually grew up in that children's home from the time she was 10 to 18.
Wow.
So now that was in 1953. There was,
you were alive then.
There was nothing like Friends of the Family. There was no national domestic violence hotline. There was no even real acknowledgement of intimate partner violence in 1953. But, my grandmother's situation is very similar to a lot of homicide victims, which is a lot of our homicides that occur during separation. So there's often litigation pending when that homicide occurs. It's like, and why would that be, right? It's all about power and control. So if I'm leaving, I'm really threatening that person's power and control and their dominance, and that's really when you see an escalation, or can. That's why protective orders are so important. It's why having attorneys like y'all that are screening for violence, that are screening for lethality and understanding that, because once you file something, a custody suit or divorce, you are threatening that person's position of dominance and control. And if someone is capable of suicide, they're capable of homicide, and they're, many of the homicides that occur in Texas are connected to a suicide.
Yeah.
So we really take all of those things, very seriously.
So just to kind of, explain the process of protective orders. So oftentimes what will happen, at least, and I'm sure it's probably similar in your office, but what will happen is somebody will come in and they'll tell us, here's all the history of family violence, and here's the things that I'm concerned about, and I have a real fear for my own personal safety.
Yes.
And so what we'll apply for is what we call an ex parte protective order.
Correct.
Right? So our client will go through and we'll draft an affidavit for them. We take that application to the judge. We present it to the judge. Judge reads the affidavit, and if he feels like there's a real risk of danger to this particular party, they'll sign this ex parte protective order, which means as soon as the abuser is served, that protective order is binding, and if they drive by your home, you call the cops and they can get arrested for violation of that protective order.
That's right. Yeah.
And then what will happen is within a few weeks, depending on the courts, it's supposed to be within 21 days, but sometimes it gets extended. We have an actual hearing where the court hears all the evidence, and then they can lay down a protective order for, up to a couple of years. Sometimes it's a lifetime, depending on the allegations. So that's kind of the process. And
yes.
I just think that it's important, because a lot of times what happens is women and men come in and they're really, really afraid about starting this process because they're worried that something's going to happen to them or to their children. And so I just want everyone to kind of understand that, no, we can put a stop to it and put things in to protect you so that you can actually move forward through the process.
That's exactly right, Christina. I think when victims are contemplating doing what I call their legal safety planning, they are dealing with the real life, practical implications of leaving that relationship. They are the experts of what they believe could happen to them when they choose to leave. So that legal safety planning is so important, and you're exactly right. Seeking that temporary ex parte order is super important. The judge would need to make a determination of a clear and present danger is the legal standard that the court would use to make that determination. And then, yes, once we can get the abusive person served, then we have, again, that temporary ex parte protective order is in that statewide database. And so if there is a violation of that protective order, it can be reported, that person can be arrested. You guys have this unique firm where you are doing both family law and criminal law, and I really love that combination because so many lawyers either have an expertise in family law or they have an expertise in criminal law. And criminal attorneys will usually be like, I don't do family law. And family law attorneys will be like, I don't know about criminal law. But in this intersection, that unique knowledge, that intersection is so important because when you're seeking that protective order and getting that temporary ex parte order, that if there's a violation, that first one is a misdemeanor. But if he violates this protective order 2 or more times in 12 months, that's a third-degree felony. Now we're really talking about some potential accountability. If that, in my temporary ex parte protective orders, it is not uncommon for us for good cause shown, get a no contact protective order, where once that person is served, they're not to text, they're not to FaceTime, they're not to show up at a kid's school, they're not to do anything. They are to stop, go find an attorney, and get some advice. But often it's a way for us to determine how very dangerous of a person are we dealing with, right? So I filed a protective order a year ago. Guy got served, and he immediately, the minute he got served, got in his truck and drove to his victim's home. That's a very dangerous individual. When they're handed a protective order, and I always have my process server tell the respondent, this is a no contact protective order. Like, here is the provision. It is bolded. If you do this, you could suffer some consequence. Don't do this, right? Because my job is not to catch somebody or trick them. My job is to keep my client safe.
Right.
So I want the respondent to know exactly how to get an A+. And how you get an A+ is you don't text, you don't, FaceTime, you don't send a WhatsApp, you don't send a Cash App. I have a client right now who he's not supposed to have any contact with my client. He's tried all various ways to have this surreptitious contact with her, and now his strategy is Cash App. He'll send her $1, and in the Cash App, send her a message.
Wow.
Well, that's a violation of the protective order, and every time he does it, it's a violation. So he's got multiple continuous VPOs because he just won't stop.
Yeah.
And so, but when someone doesn't stop, that is an indication that they are dangerous. That's because scary. It's really scary. It means that they don't care about the criminal consequence. And sometimes people who use violence will just say that, right? They will say in a text message or in a phone call, I don't care.
Right.
I don't care about that judge. I don't care about that lawyer. I don't care about, the police. I'm going to do what I want to do, right? Which is why we have to have these systems that collaborate and cooperate, take those actions really seriously, and arrest these guys, right? And create good bond conditions for them, good, bail amounts that are consistent with their behavior, And so that's a lot of what we do at Friends of the Family is not just the micro with that individual client, but it's a lot of systemic work, right? With, Judge Ramsey, for instance, who is our county magistrate, who's sort of coordinating magistration of family violence cases, And so he's really worked on some uniform bond conditions for in-family violence cases. And, what we need is sort of in every way that everybody's kind of paddling in the same direction and creating some accountability. And my position always is, if someone that uses violence can play by the rules, can color inside the lines, we can probably work through this and get them reasonable access to their kids, right? As long as we can do it in a safe and workable way, we can often get there. And I know that judges are going to want, fathers particularly to have meaningful access to their kids. And it's in very rare circumstances where they will just completely deny that access.
Had that a couple times.
It does happen. But more frequently, you're going to be looking at supervised access, and supervised access during the pendency of a case, so on some temporary orders.
Right.
And depending on how well that person does with the various orders that are in place, that will have a lot to do with what kind of agreements we can reach in the future, or whether or not we just need to go to court and say, Judge, this person just needs to be supervised, in a final order.
And I think that that's something that at least we've seen a lot. So sometimes we're not representing the victims. Right?
Yes, right.
So sometimes we're on the other end of this, where it's an alleged abuser, sometimes just an abuser.
Right.
And so, what we try to focus on is, a lot of times there's Project Adam, right? So that they're going in and they're getting the training and they have resources available. Because sometimes, some of these guys may have in fact done these things, but they're very remorseful about what had happened, and they want to change and they want to be better, and so they'll go in and they'll do the counseling, they'll do the Project Adam, and they
Tell me about, I don't know Project Adam.
Project Adam.
Oh, yeah, so I think it's 24-week family violence course.
Is it a battering intervention program?
Yeah, it's built, yeah.
Oh, okay. Is it here in, is
West Texas.
that West Texas? Okay. So we have our battering intervention program at Friends of the Family, but Project Adam is in your West Texas, because you guys, again, also unique, have multiple offices.
Yes.
Right.
And so, they'll go participate in a battering intervention program. Listen, I will tell you, I believe very firmly in working with attorneys that represent people that use violence, because I do believe that really good, thoughtful, honest representation of someone who is truly remorseful and it's not a manipulation tactic, right? Who understands that the choices that they're making are not healthy for them, their children, or their partner, can be the most effective change agent for someone who's been using violence in their relationship, right? If they have someone that's willing to speak truth to them, right, in the confines of a confidential relationship, that they're able to really, really tell you, I imagine that you have conversations like I have, which is, you got to tell me the truth, right?
Right.
You got to prepare me for what I'm going to be facing in court, because I want to help you, but in order to help you, I need complete honesty so that I can give you good legal advice. My advice is limited based on the information you're willing to share with me. And the more educated and skilled an attorney is at representing someone who uses violence, I think that's a form of community accountability. And it is a way for that person to remediate their situation. And it then equips you to be able to go to someone like me and say, Donna, what more are you going to ask for? My guy is doing BIP. He's taking a fatherhood program. He's paying his child support. He's not violating these orders. He's communicating with her on Our Family Wizard or App Close, which are these third-party co-parenting apps that we use a lot. You really interfere with my ability to maybe get my client the result that she wants if he's coloring inside the lines and he's truly doing the things that he should be doing to address the concerns. I believe in that a great deal. So if we do CLEs at Friends of the Family, we extend it to all kinds of attorneys. I mean, we're not hiding, it's not like we're going to have our secret CLE to tell you how to represent victims. Like, no, we want people to represent victims and perpetrators in a knowledgeable way, because if poor representation of someone that uses violence, someone that engages that person, and helps to escalate them, participates in that escalation, is making everything worse. Right? Like, and it can be really, really dangerous. I just had a case with a local attorney who's a pretty aggressive attorney and like really fights for his clients, and I respect him immensely for that. But we got to the conclusion of this case. It was very, very obvious that his client was using a great deal of very high-end violence, strangulation, a gun, gunplay, like a lot of very dangerous stuff. And we got to the end of the case, and we were, wrapping up our agreements. We're going to put him on the record. And I just sat with him. I got my trial notebook out, and his paralegal was there. And I was like, listen, I know you probably looked at these to prepare for today, but we're gonna look at them together. And I turned to the photographs, of my client's injuries and also a subsequent victim. And I was like, now that we're done with he didn't do this, or, she's making, now that we're done with all the theatrics, right? Let's have a really honest conversation about what your guy's doing, because he trusts you. Right. And he respects you, and you're a man, and you can talk to him and tell him that he is going to murder someone, that when he puts his hands around someone's neck like that and squeezes to the extent that they have injury on their neck and they're defecating or they're urinating on themselves, that he is that far away from killing that person. And, he will end up in prison, and he will end up with all of the regret of continuing this behavior. And you're in this really powerful position. And, that attorney emailed me the next day and said that was a very meaningful exchange for him, and that he agreed with me, that he agreed that he had a position of authority and respect in this person's life, and that it was very important for him to really try to counsel and mentor his client to try to prevent that future violence. And that is good legal representation.
So thank you, everyone who is watching us on YouTube and listening to the podcast. Again, we're the Jimenez Law Firm, a Texas-based family law and criminal defense firm. Please make sure that you like us on all social media platforms, TikTok, Facebook, Instagram, if you can find it. Then we're probably there. And then also just a friendly reminder that the things that we talk about on this podcast, it's not legal advice. This is general information. It's experiences that we've had in our cases. If you find yourself in this situation, please, please, please go and find local counsel, tell them your story, and follow their advice.